Good morning, everyone, and a very warm welcome to episode 1 in the second series of 39 from 39 minutes of webinar from members of the Planning, Environment and Property team at 39 Essex Chambers. My name is Peter Village. I'm joined by my colleagues Victoria Hutton and Dan Kozelko, and on the menu today we have the extraordinary provisions of Class E of Use Classes Order, as now amended, which came into effect on the 1st of September 2020. Is this a wrecking ball to the planning system, giving rise to greater flexibility, or is it an ill-judged and poorly conceived provision which will do great harm to the town centres it professes to protect? And we hope to answer some of those questions this morning in our short presentation. My colleague Dan will provide us with a background to the Use Classes Order and the context of the amendments brought in by the 2020 regulations, which Tora will explain. And I'll then consider some of the intended or possibly unintended consequences. Frankly, it's very difficult to know what the government intends these days of these changes. Dan will then tell us about the High Court challenge, which is being heard at this very moment in the High Courts of Justice, and we'll then have time for some questions. Now, on your screen, you'll see a Q&A button. You may send in questions in at any time during the presentation. We encourage you to do so. Please make them of a general nature rather than seeking any specific advice. If you're struggling with the technology, then please also use the Q&A button. One of our excellent webinar producers will try and assist. The webinar is being recorded, so if you miss any part of it or want to re-watch it, you can catch up on tomorrow when the recording will be available to see again. Without further ado, I'm going to ask Dan to start his presentation.
Thanks very much, Peter, and good morning, everyone. So, at the outset of our discussion today, I thought it would be useful to have a quick review of development under the 1990 Act and the importance of the Use Classes Order 1987. So, development is defined by Section 55 of the Act, and development will include a material change in the use of a building or of other land. And the usual position is that if works or a change of use is development, it will require planning permission. So see Section 57 of the Act. Now, usually a change of use is development if there is a material change of use. However, there are some explicit exceptions under Section 55(2)(f) of the Act, among a range of others. By that section, a material change of use will not be development if a change of use for the building or land is for a purpose in the same use class as the existing use of that building or land. And the relevant classes for that particular subsection are those set out under the Use Class Order 1987. Now, just as a brief side note here, it's worth saying that the order also specifies where part of a building or part of land, rather than the entire building or the entire land, can be changed to a different use in the same class. The reason why I flag that is because that's not the case for every use, and that's something to look at in the classes order. Now, the reason why it's useful to go through those basic propositions at the start is this. If something falls under Section 55(2)(f), so if something is a change of use in the same class, it is deemed not to be the same as development. And now this is different to it being permitted development under the General Permitted Development Order. And that's something that Tora is going to discuss in a moment. So, the Use Classes Order is permissive, and it allows changes of use to happen without there being planning permission. For many reasons, people such as local planning authorities might want to restrict the flexibility that that brings. And one of the ways of doing that, one of the most common ways, is through conditioning. So just to take a very basic example, if there's a Class A1 use for shops, that will normally permit a hairdresser's. What you could do is impose a condition on that use to prohibit the change to a hairdresser's shop. And it's not unusual for conditions which are used in this way to be framed around the use class. So in that example, it might be framed around Class A1 use. And this is a problem in the context of where there's changes to use classes or complete modifications. And that's something that Peter is going to discuss. One of the questions we've received sort of raises that specific point. Now, another way of restricting the change of use in a class is through Section 106 of the 1990 Act. So say you can make a Section 106 agreement with the person using the land, but they won't use Class A1 land for a hairdresser's. And in both of these situations, the changes brought in September 2020 don't change the ability to use these methods to restrict changes within the class. Notwithstanding all that, though, as Peter said at the start, the changes brought in are remarkable, and they bring remarkable flexibility for the changes that can be done within a class, particularly the new Class A. And it's understandable that those using land, or importantly, those soon to be using land, might wish to take advantage of that new flexibility. But it's important to remember that a lot of the changes that are brought in, they don't change the fundamentals of how use classes work. And an important example in that context is that when there is a change of use, it must be from an existing use to get the benefit of Section 55(2)(f). And so a use that has not materialised yet on the land or in the building, or one which has only materialised in a de minimis way, will be insufficient to then let you change in the class. And we've received another question on that, and I think Peter's going to discuss that more later. So, having set out that broad overview, Tora is now going to discuss the actual changes that have been brought in under the use classes order. Tora.
Thank you, and good morning, everyone. Well, no doubt you all are aware that something pretty fundamental has happened to the use classes order as of the 1st of September, otherwise you wouldn't be here. But what's happened is that the Town and Country Planning Use Classes Amendment England regulations have come into force. First point to note, they are regulations that apply to England only. So Wales is unaffected. The old use classes remain. Now, it's no exaggeration to say that this represents fundamental deregulation in relation to our planning system. Some, for example, Peter in opening might describe this as a wrecking ball being taken to our planning system. And given all of the press releases we've had about the intentions of Mr. Cummings, etc., this could fairly be said to be part of that. So let me just pull up a table. I'm sure that you're all fairly familiar with what the changes are, but just to visually represent this for the purposes of today, what we have here is sort of the broad uses in the left-hand column, the old use class and the new use class. And I've coloured the new use class E in orange. And what you can begin to see from there is that it is extremely broad. So we've got shops, we've got financial professional services, restaurants, offices, some industrial processes, gyms, etc., all within the same use class. And we will be coming back particularly to F2 as well later on. So it doesn't take a planner or someone who is involved in this area to recognise that actually some of the uses within Class E will have very different amenity impacts from each other. And also really to understand the level of deregulation, because of course if you have restrictive policies, so again we're going to come on to these a bit more later, but restrictive policies relating to the town centre, they could be upended by the flexibility given by Class E. So that's a very brief introduction to how the uses have changed, and everyone can go away and look at those for themselves. Now that is fairly simple. As Dan said, well, it's important to recognise what hasn't changed, and what hasn't changed, for example, is the need to implement a use before you can change your use within a use class. But there is another tricky part of the legislation which we have to be aware of, and those are the transitional provisions which have been brought in by the amendment regulations. And they apply during the material period. And we're in the material period now. It started on the 1st of September and it runs through to the end of July next year. And what that does is it preserves the old use classes in relation broadly to the GDPO. So the GDPO still refers to the old classes. That remains relevant in relation to, for example, prior approval decisions, Article 4 directions, etc. So it's clear that we can expect, assuming Class E remains in force, and Dan's going to come on to say something about the legal challenge, but we can expect some pretty significant amendments to the GDPO before the end of July 2021. Now, we can speculate what form those are going to take, but all I'll say at this point is I'm very glad I'm not drafting those, because one can immediately see the issues. For example, change of use, B1 to C3, B1 will no longer exist. How is then that expressed? Is it a general right to change from use class E to C3? Well, that would be hugely significant and probably not. So we'll just have to see how those are amended. While I'm on the GDPO, I think one point that has come up in questions asked prior to this seminar, and it's a question that is repeatedly asked, is can you make an Article 4 direction in order to get round or opt out of the use classes order? And the answer is no. So there is no general opt-out of the use classes order. As Dan has already said, the way to get round it is in relation to individual planning permissions and parcels of land via condition or section 106. Article 4 only applies to permissions granted under the GDPO. So the two things are conceptually different. The GDPO grants planning permission. The use classes order, the UCO, exempts certain material changes of use from requiring planning permission. So that's the distinction. So I'm now going to hand over to Peter, who's going to take us through some of the consequences of these changes, both unintended and intended. Peter, you're on.
As I say, it's difficult to know what the government intends, but in a sense, it probably doesn't matter. But let's look at what the consequences will be. First of all, I think I just want to point out that these far-reaching changes were introduced to Parliament on the very last day prior to the summer recess, giving no opportunity for real debate or scrutiny. And so it is perhaps unsurprising that the questions that we're now raising are ones that, had the matter been debated properly, would have been raised. I think it's first important to note the intention of the government, what they set out to do, which can be seen from the impact assessment and the explanatory memorandum which accompanied the draft regulations. And I'll just quote from the explanatory memorandum that says what is being done and why. It says the current use classes order was introduced in 1987 and has been amended a number of times since. However, the government considers that it requires a complete overhaul to better reflect the diversity of uses found on high streets and in town centres, and to provide the flexibility for businesses to adapt and diversify to meet changing demands. This is particularly important at the present time as town centres seek to recover from the economic impact of coronavirus. Modern high streets and town centres have changed, so that we now seek to provide a wider range of facilities and services, including new emerging uses that will attract people and make these areas viable now and in the future. So And it then goes on to say that the regulations amend and simplify the system of use classes in England. Well, so far so rational. Simplification of the use classes order, well, we all like simpler, to better reflect the diversity of uses found on the high street and in town centres. Well, it clearly seeks to protect and enhance town centres as they seek to recover from COVID-19 and the economic impact of it. And I note the reference to making town centres viable now and in the future. Planning policy, as you all know, at both national and local levels, has long protected the high street. It's been at the heart, frankly, of planning policy at the national and local level, and is central to the concept of sustainability. The tools by which the high street is protected are the sequential test, and in some cases an impact assessment. Yet at a stroke, the new Class E serves to undermine the policy protection that town centres enjoy. Thus, existing B1 floor space, either B1A, B or C, will from the 1st of September be regarded as Class E, which would permit the sale of goods, including food, absent any express condition which seeks to restrict such use. I'll revert to the use of conditions shortly, but it's fanciful, in my view, to imagine there are extant planning consents for B1 use, where the local authority had the extraordinary foresight to impose a condition to prevent the sale of food or non-food items. And so one can immediately see that the effect of this provision will be to open up vast swathes of floor space outside town centres for precisely the uses which planning policy protected them within the town centre. And this would be without any sequential assessment and without any impact assessment which might otherwise be potentially required. At the very least, this will offer developers and landowners a fallback in bringing forward any development proposals. And I know a lot of you who've tuned in today will be advising on this very issue. And it isn't just in relation to retail that these provisions have a serious and potentially detrimental effect. There are many local plans where the local authority has carefully assessed the quantum and location of certain types of floor space. So where it wishes to encourage, for example, research and development of space, as opposed to office, again, this new provision will do away with the distinction, making it much harder for local authorities to prescribe a particular type of use other than within the broad category of Class E. There are some particular practical problems that this gives rise to. First, the framework and the PPG clearly need significant revision to align with the new statutory framework. I should just add that there have been some minor amendments to the PPG, but the extent of those amendments are necessarily limited by the framework itself. Existing policies within local plans will be required to be updated. And as I should explain, I don't consider that local authorities are entirely powerless to still shape the precise type and extent of new development and effectively introduce controls which prohibit the selling of food and non-food items or other relevant conditions. In terms of preparing local plans, I do not consider that local authorities are required to abandon the assessment of the requirement for new, identifying the requirements for new retail, office and employment floor space within the planned period. They don't have to effectively just confine themselves to a consideration of the broad Class E floor space requirement. Policies and plans will, if anything, have to be more carefully framed in order to present a policy basis for the imposition of conditions. And if I was advising local authorities now, as to how to assess their future requirements. I would suggest that assessments continue as before, with a much greater emphasis on policy justification for seeking to impose conditions which restrict particular types of use within Class E. And so we come to the issue of conditions. Of course, the imposition of conditions is something which will become very much more important when dealing with Class E development. The starting point in relation to the imposition of a condition is, of course, the 6 tests in the renewable clause: necessary, relevant to planning, relevant to the development to be permitted, enforceable, precise, and reasonable in all other respects. There is a school of thought, one to which I subscribe, that says that the introduction of Class E demonstrates that restrictions should not be imposed if that would undermine the principle underlying Class E in the first place, the introduction of flexibility of changes between certain types of use covered by Class E. However, it's always been the case that uses can be restricted by condition. At its simplest, for example, an A1 use was restricted, could have been restricted, so that no food may be sold, or restricted the sale of goods to a certain type of non-food good. But that depends on there being, fundamentally depends on there being a policy reason and basis for such restriction. So I consider that new Class E development may be restricted by condition, provided there is the policy basis for such restriction within the local plan. This will put the onus on local authorities to future-proof any planning permission. But this still doesn't deal with the very real problem of existing floor space, which as from the 1st of September 2020 became Class E, and which is not subject to any restrictive condition. And I repeat, it is extremely unlikely that such existing development was the subject of conditions preventing retail, given Class A was by definition a different class, use class to Class B. So far from protecting the high street, this provision will make it significantly easier to change the use of existing floor space in edge of town centres, out of town and out of centre locations, which will and could have the effect of weakening the town centre at a time when we probably all accept the town centre needs all the support it can get. The matter is being considered in a legal challenge at the moment, and Dan's going to tell us about that now.
Thanks, Peter. So there is the judicial review, which is currently going on. We've had a couple of questions about it as well, so I'll try and take those in. So the judicial review is against 2 sets of regulations amending the General Permitted Development Order, and 1 set of regulations, the one we've been addressing today, amending the Use Classes Order. The challenge is brought by Rights Community Action, and it's, if you're interested, it's worth going to their website because they published their grounds, their skeletons, the orders, etc., relating to the challenge. As Peter said, the challenge began yesterday and it's ongoing today. It's before Lord Justice Lewis and Mr. Justice Holgate, and sort of raised by one of the questions that we've been posed in the chat. There was initially an interim order sought to suspend the regulations coming into force, but that was not pursued. The order suggested it was not pursued so that this would come quickly to a rolled up hearing. Now, very briefly, I'll just summarise the 3 grounds that have been advanced to challenge the regulations. So ground 1, the big ground, is that all 3 sets of regulations have no environmental assessment pursuant to the Strategic Environmental Assessment Directive and the associated regulations. And what the challenge is really saying is that the new regulations clearly set a framework for development consent, or at least modify an existing plan or programme that sets a framework for such consents, and thereby they're unlawful. The second ground was initially relating to all the regulations, but has now just been confined to those amending the GPDO. And that's the suggestion that the Secretary of State has failed to have due regard to the public sector equality duty. And then the third ground is a much broader general public law ground, ranging a whole host of things. So the Secretary of State has failed to consider responses to consultation on proposed planning reforms, has failed to take into account their own expert advice, has adopted an approach which is inconsistent and irrational, taking into account the proposed changes to permitted developments for 5G wireless masts, and also an issue related to legitimate expectations as well. So that's quite a big collection of things that have been asserted under the third ground. Now, Right to Community Action is saying that these SIs are unlawful and should be quashed. And one of the questions we've been asked in the chat is, what happens if you have a client who's already used the new breadth of the Class E classification to change to a different use? And looking at it from a starting point, the normal result would be if the statutory instrument is quashed, then it cannot be relied upon. So those changes in using the Class E use class would become a problem, because the SI would be no longer there to support that change of use. Now, there are clearly ways that you could respond to that and arguments that could be made, but at the very highest level, that would be the starting point for such an analysis. Even if the challenge is successful, however, at the end of the day, as Tora and Peter have discussed, the government is very much moving in the direction of pushing forward with striking changes to this area of planning law. So even if the SI is quashed, I'd not expect this to be the last word, and the government may try to do something to deal with the situation where people have already relied on a quashed set of regulations. So having addressed that, Tora is now going to address some of the other questions that we've had sent in today and previously. Tora.
Thank you, Dan. Well, the High Court challenge certainly one to watch. I think what we can say at this point is we clearly don't know when judgment's going to be handed down, but even if that's soon, this may well not be the end of the road. It might be something that the Court of Appeal is interested in, and who knows, potentially the Supreme Court. So it could be a challenge that runs for a while. But moving on to questions, thank you so much for those of you who have sent in questions. We had a very significant number and covering a breadth of issues. And I think what that demonstrates is that everyone is grappling with these changes. And as Peter said, there are consequences, some of them intended, and very many of them, I think it's fair to say, unintended. And we're going to try and cover as many questions as we can in the remaining time. So one question, I'm going to deal with two questions now. One question was with regards to Article 4 directions. Now, I've already emphasised that one can't use an Article 4 direction to opt out of the use classes order, but this question is different. And it arises out of the problem, which is may well come when the GDPO is amended so that it aligns with the use classes order. So the question is, if a local planning authority has an Article 4 direction in place now, which is based on the old use classes order. So, for example, preventing change of use from office to residential, so B1 to C3. Once there is an amendment to the GDPO, will that Article 4 direction fall away? If so, will a new Article 4 direction have to be made? And if so, is there potential to pay compensation, but even though the new Article 4 direction simply prevents a right which has always been prevented in any event? And the short answer to that is that it is almost certainly going to depend on the terms of the amendments to the GDPO. It's certainly something I would hope that the drafters are thinking about. I would find it extraordinary if provision isn't made for some sort of continuation of old Article 4 directions, and that local planning authorities don't suddenly find themselves in the position of starting a new 12-month compensation period. But we'll just have to see what the amendments say. Now, the second question, this has been a really popular one, surrounds the fine distinction between Class F2 and Class E shops. So just to remind you, Class F2 includes a shop mostly selling essential goods, including food, to visiting members of the public in circumstances where, Roman 1, the shop's premises cover an area not more than 280 meters square, and Roman 2, there is no other such facility within 1,000 meters radius of the shop's location. So that has been carved out of general shops in Class E in order to try and to protect local community facilities. But the question is this, does it really do that? And one question we had, to be honest, it was a series of statements, but I think I'm just going to address those and then say whether I agree or disagree. So the first point that our questioner made was that only material changes of use require planning permission. Correct. So is it true that you could have an F2 shop which changes its use? So for example, say it's no longer selling mostly essential goods, such that it brings itself back within or into Class E, but because there's no material change of use, there's no requirement for planning permission. Yes, I agree. And that is a very important principle, highlights a very important principle. Just because you change use classes does not mean there's necessarily a material change of use. Whether a change of use is material or not depends upon the circumstances, including amenity impacts, and it's a matter for the decision maker. So yes, I think that is possible. There are ways of getting yourself into Class E by changing a use, but not in such a way as to be a material change. Second point the questioner made was, is it possible for a Class E shop to become a Class F2 shop overnight because a nearby facility within a kilometre has closed down? Yes, I think that is possible. The PPG makes clear that whether a shop falls within a Class F2 use class will depend upon an assessment of the facts at the time of the relevant determination. So yes, I think there's considerable fluidity here, and one has to be very careful to assess the facts as at the time of the decision, and just to be aware of what's closing down around you. The third point is, well, what are essential goods? And that's a very good question. It reminds me of when we were all back at the beginning of lockdown, and there were reports of policemen checking people's shopping baskets to see whether they had cornflakes and milk or whether they'd bought an Easter egg. The cornflakes being essential, the Easter eggs not being essential. Well, there's a lot up for grabs here. Essential goods isn't defined. I think we'll all agree cornflakes are essential. But what about butchers, bakers, and candlestick makers? Well, lots to argue about. In my view, butchers and bakers are most likely to be selling essential goods. Candlestick makers at best borderline, I think probably not. But it just demonstrates that there are going to be grey areas and lots for all of us to be arguing about. And with that, I'm going to hand over to Peter to answer a couple more from the postbag.
Actually, we've just, you've answered one of the questions I was going to deal with. So there's just one further question that we've got, and I think we've got time for one further question before our 39 minutes is up. And the question was, what weight may be given to policies and existing adopted local plans which accord with the framework, but which don't take account of new Class E? Well, I mean, the answer to that is it depends what the nature of the development is and whether there is an obvious likely conflict. The policies in a local plan which fail to take account of Class C may well be out of date. It's not necessarily the case, because I mean, if I applied for planning permission for Class E development, intending to develop it for offices, and the policy in the plan allocated the site for offices, then clearly one would say that there isn't any conflict. But in a case that I recently had, in fact, in the case of the inquiry started on the 1st of September, we're still awaiting the decision. The policies in the plan precluded any Class A use on the site and precluded any Class B1A use. They were policies which sought to retain the site effectively for Class B1C. And we were therefore able to make, in my view, a very strong case that in fact the policies in the adopted plan were out of date, because the effect would be to allow us to have Class E development on the site. It's slightly complicated and nuanced because, of course, the provisions don't, in fact, come into force until those provisions don't come into force until July next year. But we were looking prospectively at what the position would be as well. So the answer is that I think you can make a case that policies in a local plan which fail to take account of Class E are out of date. So far as the framework is concerned, that too appears to be out of date. And the weight which may be accorded to its provisions will accordingly be diminished, simply as a matter of material consideration. So that's something which will change once the new NPPF is published, but we are still awaiting that, and we don't know when that will happen. Now, I think that, let's check, we've still got, I mean, a lot of questions have been asked, but I think we've more or less covered as many as we can. All I would say is that we will, of course, keep you updated with the result of the High Court challenge. We don't know when precisely the judgment will be given. It's a divisional court case, so that means that the appeal is likely to go straight to the Supreme Court rather than go to the Court of Appeal, which means that there will be likely to be a definitive assessment of this issue. I'm not sure before Christmas, but certainly in the next 3 or 4 months. So that's all there is from us today. Thank you very much indeed for joining us. It's a pleasure, as always, to have you. And without any further ado from me or anything else, goodbye.
Goodbye.
Bye.